Well, hello. Welcome to today's briefing. I'm Jennifer Lim. I'm the Executive Director of Republican Women for Progress. Our organization was one of the organizations that signed on to one of the many amicus briefs, some of which we'll hear about today. We'll be starting in just a few moments, but I wanted to remind everyone that this is an on-the-record briefing. As you saw, we are recording right now. We'll have each of our panelists speak and then leave about half of our time at the end to take questions following the briefing. I'll put my email address in the chat for everyone if you have any follow-up questions or requests after the briefing. And with that, I will turn it over to Kodiak Hill Davis, who is the Vice President of Government Affairs at the Niskanen Center. She will be your moderator for this event. In her role at Niskanen, Kodiak is responsible for developing advocacy strategies to advance Niskanen's legislative goals across all the policy departments. She works with a wide range of legislators and coalitions to pursue pragmatic approaches to the biggest challenges of the day. All of this, of course, makes her the ideal moderator for us in today's briefing. So with that, I'll turn it to you, Kodiak.
Thank you so much, Jenny. And good afternoon, everyone. And thank you again on behalf of Common Cause and Southern Coalition for Social Justice for being here today with us to discuss the Moore v. Harper case ahead of tomorrow's oral arguments before the Supreme Court. As many of you know, this case stems from the legal fight over whether state courts have the power to invalidate unconstitutional electoral maps in North Carolina. At worst, an unfavorable decision in Moore could upend election law and destabilize the checks and balances that have long been a cornerstone of our democracy. In their brief, Common Cause, Harper, and the League of Conservation Voters describe how North Carolina lawmakers' arguments in Moore v. Harper are inconsistent with the text, structure, and history of the U.S. Constitution, contradicting centuries worth of well-established precedent. Our speakers today will discuss these arguments, as well as the independent state legislature theory and how this could disrupt our election landscape on a level we've never seen before. And while there has been much press from both sides about this case, what we want to highlight here today is the broad bipartisan coalition the respondents enjoy, which includes former Republican elected officials, conservative nonprofits, former members of the judiciary, election law experts, constitutional historians, high-ranking retired military officials, and even a co-founder of the Federalist Society. To that end, I am pleased to present both of our prestigious speakers. First, we will hear from Judge J. Michael Ludig, who serves as part of the counsel team for Common Cause, and he'll tackle an explanation of the legal arguments in Moore v. Harper and what we can expect to hear tomorrow. Judge Ludig served on the U.S. Court of Appeals for the Fourth Circuit from 1991 to 2006. And prior to his time on the bench, Ludig was assistant counsel to the president under Ronald Reagan and clerked for then Judge Antonin Scalia and for Supreme Court Justice Warren Burger. He also served as Assistant Attorney General in charge of the Office of Legal Counsel in the Department of Justice under George H.W. Bush. After leaving government service in 2006, he entered the private sector where he worked for both Boeing and Coca-Cola. Next, we will hear from Ben Ginsberg, co-chair of the Election Official Legal Defense Network, as well as former counsel to George W. Bush campaign and a number of Republican candidates over the years. Mr. Ginsberg is a nationally known political law advocate and compliance expert with 38 years of experience representing participants in the political process. His clients have included political parties, political campaigns, members of Congress, state legislatures, PACs, governors, vendors, donors, the whole gamut. And he's also represented 4 of the last 6 Republican presidential nominees. Mr. Ginsberg will lead us through the independent state legislature theory and how this could disrupt election law. So before I invite our speakers up, I want to encourage reporters who may have questions while our speakers are presenting to use the Q&A button to type out your questions And after all three speakers are done, we will start the questions with the Q&A function. And as Jenny noted, we are recording this entire session while streaming it online. And we will also be sharing a recording of the briefing after the fact. And now I would like to welcome Judge Ludig to speak.
Thank you, Kodiak, and thank all of you who are joining us here today. It's my great privilege to be here with Ben, who is a longtime friend, and Ben will be the one who will answer all of the election law / political questions that you have today. I know little to nothing about those. And what I'm going to do today is try to help all of you understand the legal case, the constitutional case that's going to be argued tomorrow in Moore versus Harper. The constitutional question is exceedingly complex. The constitutional analysis that will lead to the resolution of that case by the court is exceedingly complex. So much so that even today there are very few lawyers and even constitutional lawyers who fully understand the case and its ultimate resolution by the Supreme Court. But as I've said publicly many times, the Moore versus Harper is the most important case for American democracy since the founding. That's not a hyperbole or overstatement. That's a factual statement. Why is that true? The court will decide in Moore versus Harper essentially all of the most important election law issues under the United States Constitution, both as those issues relate to the elections for the presidency of the United States, as well as for the elections of Congress, and in particular, in Moore versus Harper, the drawing of legislative congressional districts by the states, which is a power given to the state legislatures by the elections clause of the United States Constitution. So the specific issue before the court is whether the state Supreme Courts may review the state legislature's redistricting decisions under the state constitutions. The argument being made by the petitioners, as you're well aware, is grounded in something called the independent state legislature theory of interpretation of the elections clause. The petitioner's argument is that because the Constitution empowers the state legislatures to prescribe the time, place, and manner of the holding of congressional elections, in this instance, the manner of drawing the congressional districts. Petitioners argue that the state Supreme Courts and therefore the state constitutions play no role whatsoever, so that the state legislatures may draw those districts and redistrict the states unfettered by the state constitutional provisions that would otherwise be drawn into question and apply to the state legislature's legislative activity in the redrawing of the districts. Their argument is simply because the Constitution gives that power to the state legislatures, there is no judicial review by the state Supreme Courts. The respondents, for their part, argue that no, the mere fact that that power is given to the state legislatures doesn't mean that there's not state judicial review of the exercise of that power. And they argue, in my view, quite persuasively, from the history since of our country since the founding, and in particular the history at the time of the framing of the Constitution, that the framers of the Constitution never intended to eliminate state judicial review of the state legislature's redistricting decisions, which actually existed since the founding of our country, but that existed at the time of the framing of the Constitution via the then existing state constitutions. That is, the state constitutions at the time of the framing, and thereafter, for the first 30 years after the framing of the Constitution, the state constitutions regulated the federal elections and the state legislatures in their process of drawing the time, place, and manner for the congressional elections. And for 233 years, therefore, it's never even been suggested that the state Supreme Courts would not have that review authority. So I think with that, Kodiak, I'll stop and await questions from those who are with us today.
Thank you, Judge Ludig. And now I'd like to turn it over to Mr. Ginsburg.
Thank you, Kodiak. Thank you for having me. It is always an honor to be on a panel with Judge Ludig, and I am so relieved to be on a panel with him because all those nettlesome constitutional questions will be all his. I'm happy to deal with the political hacker. And I certainly endorse what Michael had to say about the case. And I want to give you my perspective as a practitioner in election law and the effects of adopting the petitioner's theory of independent state legislature, and why it would be so disruptive and confusing to the way we run elections, and really to many of our citizens at a time when trust in elections needs bolstering and does not need another unnecessary and unwarranted assault. The practical ramifications and unintended consequences, including political unintended consequences, really stem from a couple things. First of all, it would upset the settled expectations that people have about elections and create a huge amount of legal uncertainty around elections as tough administrative questions get sort of ping-ponged back and forth between a state legislature and what a state court might try and do, and whether you would have different rules or not for federal and state elections as they were going on. It would also cause a huge amount of confusion for election administrators because of the inevitable differences that would come about for the way you run federal and state elections on the same ballot on the same day. It would certainly also increase the odds that state legislatures have the power, if this is adapted, to actually replace the popular vote in determining who wins elections. And as well, it would sort of flip our system of state and local control of elections on its head by making federal courts the routine arbiters of state law, because no matter what ISL does, it can't take away the federal constitutional protections. So at a time when the US Supreme Court seems fairly intent on trying to reduce its election law caseload. This, in fact, would create an explosion of, I think, federal litigation right close to the elections. So with that as a prelude, let me give you 5 quick points from a practitioner's vantage point about what adoption of the petitioner's ISL theory would do. Number 1, make no mistake how big a change it would be. It would be the first time since our founding that essentially a legislative branch could go unchecked, and especially in the sensitive area of election. It would have an impact on who decides who wins elections, which are supposed to reflect the will of the people. But in fact, the petitioner's theory could provide that ultimate decider of elections to a legislature, irrespective of the popular vote. And it would also let our popularly elected officials have sort of an unprecedented power to keep themselves in power with, as Michael described, gerrymanders that could take place forever. Point number 2, recognize who legislators in dealing with federal election cases would no longer have to pay attention. First of all, gubernatorial vetoes. Presumably, if the petitioner's theory is adapted, then gubernatorial vetoes of legislation would become irrelevant. Also irrelevant under the theory would be referendum and initiative passed that impacted federal elections, whether that was redistricting criteria or things involving voting, such as registration and absentee ballots. Also, if legislators reserve the certification of elections to themselves, and you've seen some initial precedents of that in a few state laws already in 2021, then actually legislators could determine the winner of the popular vote in elections. And so the administrative powers that are often granted and taken upon election administrators would also be reversed. And so there is some real tension in how a legislature passes a law and the detail that's actually needed to implement that law. That traditionally falls to our election administrators now, but could easily be taken away from them. Point number 3 is the adoption of the petitioner's ISL theory would really unsettle established legal practices. And as I mentioned before, lead to what I think would be a flood of federal court litigation is sort of the only island left in the sea to lap onto. That's a good result for the Society of Hourly Billers, of which I used to be a part, but frankly, it is no good for anybody else. It is important that unfettered and uncheckable authority for state legislators over federal elections and how radical that principle is. It would really, as well, from a US Supreme Court perspective, negate what they have been trying to do to extricate federal courts from last-minute election disputes, something called the Purcell line of cases. And this would essentially stand those rulings on its head. Point number 4 is that it would make a number of things true and give the power to the legislature. Congressional districting, enabling one party to put itself in power in perpetuity. Secondly, presidential elections. A legislature, if ISL is adapted, could sort of say, wow, this election doesn't smell right. We're going to ignore or invalidate the popular vote and pick a set of electors that we think is right. It would also give them, as I mentioned, the power to certify election results and really have a bad impact on what happens in elections in emergency. For example, were there a natural disaster, a Hurricane Sandy? Election administrators are now empowered to jump into the breach under somewhat vague wording in state law. If ISL is adopted as petitioners envision, then it really is the legislature that would have to move in emergencies to set those rules. And for any of you who have covered state legislatures, quick movement into the breach is not their forte. Yet the rights of people to be able to cast ballots would be at stake. And fifth, it's worth talking some about the unintended consequence. We ought not be misty-eyed about where the independent state legislature theory sprung. It's not like somebody sort of woke up and said, well, gee, just for the good of constitutional consistency, we should change the way we've been doing things for the last 200 years and adopt an independent state legislature theory, which gives all authority to the legislature. Rather, this theory gained prominence really after a successful Republican redistricting in 2010, and a pretty valid political observation that a source of long-term strength for the Republican Party and particular programs could be implemented at the state level if state legislatures were given more power. So I think that's the way it came about. There's one interesting unintended consequence to look at, and that really is in the redistricting area. What is true is that if the theory is enacted, a legislature will be able to continually pass maps that keeps it in power. So what's the dynamic of it? My view of the 21-22 redistricting process was that Republicans had a much better cycle in terms of what the courts did than Democrats did. That Republican courts upheld maps in states like Texas and Alabama and Florida, and that in Democratic states where Democrats control both branches of the legislature, they suffered legal setbacks. New York, Maryland, New Mexico. So that I'm not sure if you unwind the New York map, which would be possible if ISL is adopted, that Democrats don't pick up enough seats to take over the House of Representatives. And it's also important to remember that if ISL were adopted, the shackles would come off redistricting commissions. Redistricting commissions would no longer have the power to draw maps that would fall back to the legislatures. That would allow California and New Jersey Democrats to be able to draw maps to keep them in power. And remember that Michigan flipped to Democrat this time after a commission. Democrats control the Michigan legislature for the first time in almost 40 years. They can now come back and sort of put that state congressional delegation out of control or out of reach. So there are unintended consequences on a very political level that has nothing to do with the legal arguments, but I think which are important to keep in mind in looking at the case. So with that, Kodiak, let me turn it back to you, and I know we'd be happy to take questions.
Well, thank you both so much for your comments and walking us through this very, very complex case and the potential consequences of a decision. I'm going to exercise moderator's privilege while we have our attendees generate some questions. So I'm going to start with one of my own. Could you walk us through the range of decisions that SCOTUS could hand down tomorrow or in the coming weeks, from the most kind of sweeping ruling in favor of the independent state legislature theory to the types of more kind of narrow rulings that you see as possible on either side? And I know that takes a little bit of prognostication, which I myself am always a little reluctant to do.
Yeah, Kodiak, let me take the first stab at that. And first, let me make something clear, very important to make clear, which is the independent state legislature theory was the centerpiece of the effort to overturn the 2020 presidential election. But it was the independent state legislature theory as it applies to the electors clause of the Constitution, not the elections clause of the Constitution, which is at issue in Moore versus Harper. Nonetheless, because the operative language of the electors and the elections clauses is the same, the court's ruling in Moore versus Harper under the elections clause will all but decide the independent state legislature theory for purposes of the electors clause of the Constitution. Then turning to your question, Kodiak, the big decision before the court in the first instance is whether there is state Supreme Court review under the state constitutions of the legislature's redistricting decisions. For reasons that the respondents have laid out well in their brief, and that I've written in an article in the Atlantic, I do not believe that there is any support whatsoever in the constitutional text, nor in the history of the framing of the Constitution that would support that most aggressive version of the independent state legislature theory that the petitioners are arguing for. That said, to begin to sketch out the range of possible holdings by the Supreme Court, if the Supreme Court were to embrace that most aggressive view, then that would represent one end of the continuum of possible holdings. That would be the most aggressive view possible. I do not believe the Supreme Court will hold that. As I've said in the Atlantic article, I believe that rather the court will reject that most aggressive view, and then it will turn to what I believe is the only real question before the court, namely, to what extent does the Supreme Court have the power to constrain the state Supreme Court's power in the interpretation of the state's own constitution? This would be an extraordinary and unprecedented, but the court does have that very limited power to, in effect, tell the state Supreme Courts how they must interpret their state constitutions. And that power in the Supreme Court derives from the elections clause conferral of power on the state legislatures. So the Supreme Court can limit the state Supreme Court's interpretations of their own constitutions in order to ensure that the state legislatures are free to prescribe the time, place, and manner for the holding of congressional elections. And that's what I expect the court to do. I expect that the standard that they adopt will be exceedingly narrow and exceedingly deferential to the state Supreme Courts. But I do believe that's will represent the other end of the continuum of possibilities.
I would very much agree with Michael's analysis of that. I think the court will not adopt the petitioner's vision of an independent state legislature theory, just for the reasons that I mentioned. Allowing state legislatures to go completely unchecked in the sensitive area of federal elections, I think, is unlikely. There's a 200-year history of not doing it the way that the more plaintiffs are asking. It's clear from the Florida recount in 2000 that you can't change the rules of the game after it's been played. Yet a lot of what the legislature would be able to do under this theory would be changing the rules of the game after it's been played if they didn't like the result. And the fourth reason is the case management issue, that it will, and I say this as a practitioner and laid it out in the amicus brief I filed, provide any number of mirthful causes of action for practitioners on both sides to bring, if in fact this was the reality. I think there have been some instances with the increase in elections litigation, especially in the 2020 cycle, but also some in 2022, where there are courts who did more than just judge the constitutionality of a law, and in fact applied remedies that frankly were the equivalent of legislation. And so I agree that I think that's probably an action where if the court's looking for a middle ground, they might well go.
You know, in that regard, everyone will be focused on the discussion tomorrow surrounding the Supreme Court's 2019 decision in Rucho, R-U-C-H-O. That was the case in which the Supreme Court bowed out of the redistricting decisions at the federal level on the reasoning that it's political, and the Supreme Court had no business in it. But in holding that, the Supreme Court observed that those who would challenge redistricting were not without recourse, because the state constitutions govern the redistricting decisions. That, however, is what's called dicta. That is, it's not a holding of the Supreme Court, so the Supreme Court's not bound by that. But that was consequential dicta, and it would be extraordinary for the Supreme Court to rule today that there's no state judicial review under the state constitutions, given what they said in Rucho.
Thank you both so much for your thoughtful answers. I'm going to ask Mr. Ginsburg a question about something he mentioned. It was the second point for those of you who are taking notes. And it had to do with gubernatorial vetoes, which is not something I've spent a lot of time thinking about. And I'm not sure that I've heard that come up as frequently in this discussion. Can you unpack that a little bit? And I'm happy to give you the context of how you said it, if that would be helpful.
Well, let me sort of recount it. I mean, as of right now, legislatures have to worry when they pass legislation about gubernatorial veto. If in fact state legislatures are not subject, have the power, the unchecked power to pass legislation involving federal elections, they will be able to ignore gubernatorial veto. So that if a governor were to veto an elections bill, it essentially would have no authority, no weight in this scenario.
So this is, I think, one of the most interesting aspects of the conversation that we're having today and about the case is that you've both made the point about unintended consequences and how far-reaching and destabilizing the outcome of this case could be. So I am not seeing other questions, but there was a question asked originally in the chat, and I'm happy to read it in and have Judge Luding answer it, just in case the rest of the attendees didn't see it. So I'll do that now. And then if we don't have any other further questions, I'll turn it back over to Jenny Lim, wanting to be mindful of everyone's time and busy schedules this time of year. So the question comes from Stuart Gerson. Given the clearly ascertainable history of the framers' intentions and the actual practices during the early days of the Republic, what, if anything, is more telling us about the limits or application of originalism as a judicially limiting interpretive mechanism?
Stuart Gerson is a long time and dear friend of mine. We worked together in the Department of Justice 100 years ago, and I actually typed out an answer to Stuart while we were talking, and that answer was this: in my view, because of the complete absence of evidence anywhere at the time of the framing and since the founding, that the framers intended to eliminate state judicial review. If this Supreme Court were to hold, nonetheless, that there is not state judicial review of the legislative redistricting decisions, I believe that would represent the death knell for originalism. Now, I think I should say to you that I believed that I wrote that that the Supreme Court's originalist analysis in the Bruin case, the Second Amendment gun case out of New York last term, I said that the Supreme Court's originalist analysis would represent the death knell for originalism. We don't have time to get into that today, but I just believe the Supreme Court is engaged in treachery on its originalism analyses, and like I said, if it goes the opposite way here, I think that would represent the death knell for originalism.
Oh, it looks like we have another question saved by the bell. I thought you were going to be able to wrap up and scoot out of here a few minutes early, but no. Thomas Griffith asks, how do you explain the sympathy for the independent state legislature theory expressed by Justices Thomas, Alito, and Gorsuch, and the interest in the theory expressed by Justice Kavanaugh?
Well, I'll take that so that I can say that that's not a fair question. Because if it's the Tom Griffith that I know, that is the Tom Griffith, the former colleague on the United States Court of Appeals. Tom was on the District of Columbia circuit, not the Fourth Circuit, but he too is a dear friend, and he knows better than to ask a question of me in a public forum. But it does give me the opportunity to say this. Importantly, that no Supreme Court justice of the 6 now who have commented about the independent state legislature has ever suggested that they were even tempted by the most aggressive version of it that's being argued for by petitioners. The genesis of the independent state legislature theory was in a concurrence by then Chief Justice Rehnquist, joined by Justices Scalia and Thomas in Bush versus Gore. And Bush, in that context, by the way, the issue involved a statutory interpretation, not a constitutional provision. And you know, in my terms, the Chief Justice and the concurrence breezily, laid down a marker that there must be some limit to judicial review in order that the state legislatures be accorded the authority to prescribe the time, place, and manner of holding elections. As I said earlier, that's unobjectionable. That is exactly what the court is going to do in some fashion. It's going to limit the state Supreme Court's judicial review in order to ensure that the state legislatures have the power that's accorded them by the Elections Clause. So Tom's question is what explains the temptation. That's what explains the temptation. And that's what I would say to all of us gathered today, that this is not a radical case. It was not radical for the Supreme Court to take this case. The Supreme Court had an obligation to take this case. Arguably, it had an obligation to take this case back in December of 2020 in the context of the Electors Clause and the 2020 presidential election. But the court did not want to be interceding in an election in the same way that it was criticized for doing in Bush versus Gore. But all of us knew that at the first opportunity, the court would take the case to decide the independent state legislature, theory. And it just so happens that the North Carolina case was in the pipeline and the first to make its way to the Supreme Court. And it was just by happenstance / coincidence that Moore versus Harper raises the issue, not in the context of the Electors Clause, but rather in the context of the Elections Clause. So there's been a lot of criticism of the court. People are just mystified that the court would have even taken this case because, in their view, the state Supreme Court did what it should do. But the court doesn't just take cases to reverse lower courts. It often takes cases to affirm those courts. And for that reason, you can never draw any inferences as to what the court will do from the mere fact that it takes or does not take a particular case.
But let me agree with Michael on that, and just note that after the 2000 cycle and the prelude to this, the independent state legislature theory was invoked many, many times by many, many parties in cases, including redistricting. And so there must have been a half dozen states, including New York Democrats, that appealed their maps and added ISL to it, so that as a matter of case management, as well as the principles Michael articulated, the court should have taken this case. It's also worth noting a little bit of the context in 2000 that led to the rankless concurrence. There was a period of time in Florida in December where in November, it appeared as if there might not be a certified election. In other words, there would be no electors in the Electoral College for Florida, which really led to the question of, in that instance where the state processes do not succeed in determining a winner for the Electoral College, does the legislature have the authority to step in and name the slate? Because otherwise the entire state of Florida is disenfranchised in the Electoral College. So that that Bush versus Gore concurrence came up in a much different context than the sort of, we're going to exert a lot of political muscle and perpetuate our majority, which is what this one.
Thank you. We have another question has come in by an anonymous attendee. Are there any other cases in the pipeline that could make it to the Supreme Court that will look at the issue of the independent state legislature theory? And I think you alluded to them.
Yeah, the court will eventually decide the independent state legislature theory in the context of the Electors Clause, and they will decide that. I believe, prior to the 2024 election. Because whatever they decide in Moore, as a matter of technical constitutional law, it will not necessarily apply to the electors clause. And as I said, it's really the 2020 presidential election and Trump's effort to overturn that election, based upon, in large part, the independent state legislature theory that has brought this issue to the fore for the first time in 233 years of the country's existence.
Well, gentlemen, I do not see any other questions coming in. And given that we've been in this weighty conversation, I wonder if you have any final thoughts or key points that you think we should keep in mind as we prepare for tomorrow's arguments and the potential outcomes.
I would just remind everyone of what I've said earlier, which is this is a case in the Supreme Court of the United States. It is a politically fraught case, perhaps the most politically fraught case ever decided in the Supreme Court, with grave consequences for elections, the federal elections, and democracy itself. But within the Supreme Court, it is nothing but a question of constitutional law and constitutional interpretation. And it has been briefed in exactly that way. And the justices are going to decide this case based upon that constitutional law, without regard to the political implications of their decision. That's actually why I'm encouraged, because as I see the law, the constitutional law, well, as I see it, actually in this case, the Supreme Court would affirm the North Carolina Supreme Court's decision, if for no other reason than that the North Carolina legislature itself has authorized state Supreme Court judicial review under the state constitutions of its own legislative redistricting decisions. So in my judgment, if for no other reason, then the court will affirm this particular case.
I am sure that Judge Ludick is right, and that this will be decided purely on the basis of constitutional law, with the justices not looking at all at the political situation and practical ramifications. I think if any of them sneak a peek in the privacy of their studies late at night, what they will see is some pretty dire consequences to the American political system and the electoral system. And so I think it undoubtedly will be decided on pure constitutional grounds, and we'll all be fine.
Well, I always appreciate when a conversation like this can end on a high note. So with that, I'll turn it back over to our host, Jenny Lim.
Hello, thank you so much, Kodiak. And thank you so much to Judge Ludig and Ben Ginsburg for joining us today, especially since it's the day before oral arguments. And thank you everybody for joining us on the Zoom and for asking these amazing questions. A recording will be available afterwards and sent around. And if you do have any further questions, I put my information in the chat box. And excellent. Well, yes, thank you so much. And we'll let everybody get on with their day. And thank you so much for attending.
Thank you.
Thank you.